Hello, this is Leisha Francis reporting for the NB Media Co-op in Elsipogtog First Nations Reserve. A Mi'kmaq senator is pushing for legislative changes that would eliminate the second generation cutoff from the Indian Act. It's a rule that prevents people from passing on Indian status to their children following two consecutive generations with one non status parent.
I chose to champion this amendment because I believe there is nothing more vital to the survival of First Nations than this change. The fact is that we cannot govern who First Nations fall in love with. This change says, love who you love, and do not worry because your children will not fall by the wayside just because you choose to parent with someone not First Nation.
On Tuesday, Senator Paul Prosper's amendments to Bill S2 were approved by a Senate committee in a 10-1 vote. A number of Indigenous rights organizations and leaders across the Wabanaki region have also thrown their support behind the initiative, including MTI, the Assembly of Nova Scotia Mi'kmaq Chiefs, the Mi'kmaq Grand Council, and at least one Wolastoqey chief. But the federal government has already signaled opposition to the changes introduced by Prosper to Bill S2.
I wish to briefly put the government's position on the record. Bill S2, as the chair just underlined, is primarily a response to Nicholas versus Canada. The bill will ensure entitlement to registration for individuals and their descendants who lost it through enfranchisement, affecting approximately 3,500 individuals. This is the core of the bill, and I question whether the amendments fall within its scope. As you all know, there is also a court deadline that must be respected, April 30th, 2026. The minister must exercise her constitutional duty to consult. The government is committed to finding ways in which to address the second generation cutoff.
We requested an interview with Minister of Indigenous Service, Mandy Galmasti, the first Indigenous person to hold that position, but she was not available.
It's always been a plan, we know, for the federal government to get rid of Indian people, but it's important to recognize that we're talking about belonging, we're talking about people's lives, we're talking about identity, we're talking about culture, we're talking about tradition. It's incumbent upon every government official to recognize that that we have constitutionally protected rights as Indigenous people, and there is an obligation upon government to respect those rights, even though if that may mean funding a few more Indian people.
Senator Prosper recently held a news conference in Fredericton where several Indigenous leaders from the region renewed calls for the second generation cutoff to be eliminated.
46% of my community members are 6'2" registered. I'm on the brink in at least 10, 20 years, I won't have any registered Indians in my community because of a bill that the government of Canada has on the table. Today, we have the opportunity to change that. We have to, of course, lobby folks in Ottawa to ensure that, of course, this bill gets through.
We want Canada immediately to stop the discrimination against our Mi'kmaq and Mi'kmaqs under the Indian Act and keep all stall in the end of their discrimination against Mi'kmaq.
The NB Media Co-op asked people of Elsipogtog for their take on the issue.
I mean, if you want to have a kid with a non-native person, your kid should be able to get status, in my opinion. Because, like, yeah, I mean, you're still native. Your dad's a native. Why wouldn't you be a native?
My comment is, if you want status, come live under us for a little bit and see if you want it then. I've lived on the reserve and off reserve, and it's two different lifestyles. To claim that for money purposes only, I wouldn't agree with. But if you're into the culture and you're into the people and the beliefs, then yeah, I'd be open to that.
I think that it is an issue that a lot of people, especially people I know of, face where they get that 6'2" and then the cutoff. Like I personally know of my nephew got cut off from that eligibility, but it's also it begs the question of how are they going to fund? Like, is there going to be an influx of too many? Um, what would be the correct term? Too many people within the system. Like, how could the bands afford it? I think that it is something a lot of people do need, but I think that we also have to build upon the band membership, and how that funding goes about. Just so there's a lot of people that are struggling, and this doesn't impact the people struggling more.
We go now to our interview with Senator Paul Prosper. Stay tuned. Hello, I'm Leisha Francis, reporting for the NB Media Co-op from Elsie Brooktuk.
And I'm David Gordon Koch, reporting from Moncton.
And today we are speaking with Senator Paul Prosper. He has proposed changes to the Indian Act that would get rid of the second generation cutoff. So, Senator Paul, can you explain for people who might not be familiar what the second generation cutoff and why it is a problem?
Sure. Thank you for that question, Leisha. The second generation cutoff is something that had been introduced within the Indian Act through Bill C-31 in 1985. And what that provides is two successive generations, if you can imagine, of parenting between a status Indian and a non-status person. Within two generations of that, and one can think about it in terms of the grandchildren, they would no longer have any status under the Indian Act. So just to give you a further example, full status, as some people refer to it as 6-1 status, it exists where you have two status parents. And if you have a 6-1 status person, having a union with a non-status person, let's say non-Mi'kmaq, the children of that union would still be status, but they would be 6-2 status. Now, those children, if they were to in turn have a union and children with the non-status person, then the children of that union, the grandchildren of the initial, grandparents, let's just say, then they would no longer have any status. So it's a formula whereby within two successive generations of children from a union between a status person and a non-status person, that you have children who do not have status.
Yeah, that's unfortunate. But I know exactly what. Yeah. So there's a bill. There's a bill currently before the Senate, Bill S2, and today a Senate committee accepted the changes that you proposed. Briefly, what is the purpose of Bill S2, and what are the changes in it that you have put forward?
Sure. The purpose of Bill S2 responds to a court decision out of British Columbia, which where the plaintiffs, sort of the descendants of persons who have lost status due to enfranchisement provisions within the Indian Act. So historically, there were certain instances, both voluntarily and involuntarily, where if an Indian person, for example, wanted to vote, that they would have to give up their native status, their Indian status, if they own property or got a university education. These were all processes that provided that that person, that native person, that Indian person would have to give up their status in order to have that certain right. It has been said as well that it was used as a tactic during times of residential school as well, where people were forced to enfranchise and to prevent their children from going to residential schools. So it's a rather sad circumstance. And what this bill seeks to do is to restore status back to roughly the projections for about 3,500 at a minimum. People would get their status back from that bill. The amendments I brought forward was to expand upon the entitlement or eligibility to be registered as a status Indian beyond the boundaries of S2, which supports the Nicholas case, to further get rid of the second generation cutoff that was introduced back in 1985. Since it is viewed by many people, academics and First Nation advocacy groups, as a discriminatory provision that offends the Charter of Rights and Freedoms, discrimination based on sex and certain, and something that offends the equality provisions within the Canadian Charter of Rights and Freedoms. And so we sought to get rid of the second generation cutoff to restore status to persons who have one parent, if they could trace, their ancestry back to one status person, then they would equally have status, and that status would be passed down in perpetuity through successive generations. They would also be entitled to be registered on their band list, the list that they're most affiliated with through the status parent and their band list. It would also seek to get rid of the 1985 cutoff, which basically for children born before April 17, 1985, there was those children would, of a specific union between two parents, would have 6-1 status, whereas children born after April 17th, 1985 would have 6-2 status. So there's an inequality right there just by the mere fact of a date, determining the type of status. And so it also gives the federal government a bit of time before, these provisions come into legal effect. It gives government a year to get their affairs in order before these provisions apply legally within the act.
Okay. And so, with that year, what kind of effects would we eventually see in our communities then?
That's a very good question. Currently, the federal government is engaged in a collaborative process to examine the second generation cutoff. But in addition to that, they're delving into the voting thresholds for band membership, for bands that want to have their own band membership codes through Section 10 of the Indian Act. So that process has been ongoing for some time. But in addition to that, those discussions and consultations, as they are referred to by government, there are also larger considerations with respect to citizenship and communities and nations having that ability to determine citizenship of their members within their respective communities as well. So it involves notions of citizenship. It also involves notions of status, and it also involves notions of the development of membership codes for each band if they so choose. So it gives government that window of a year to come up with an approach that sort of deals with those issues and climatizes those First Nation communities and also the federal government to come up with a way to address the removal of the second generation cutoff and restoring that to a one parent rule.
Okay. So we were talking about the process, and the Standing Senate Committee on Indigenous People have approved your amendments. And what will that look like next, or what will happen next?
Again, another really good question, Alicia. So you can only imagine with any bill, there's a number of hoops it has to go through.
Yeah.
Since this is an S bill, S2, it started in the Senate, so it's got to go through all processes within the Senate. And then if it's successful, it goes over to the House of Commons and it has to go through their processes as well. So we're at the stage of committee. It was referred to APA, the Standing Senate Committee on Indigenous Peoples. We've listened to over 50 witnesses, over 10 meetings. We heard a lot of evidence, most of it going towards the removal of the second generation cutoff. The committee, followed that evidence and advice to get rid of the second generation cutoff. Most members within the Senate, have that corporate knowledge of dealing with this issue in previous bills as well, like S3, which dealt with another court decision involving status, known as the Deschanel decision out of Quebec. And so now it's coming out of committee, and the report is going to be reported back in the Senate chamber. And and if there are no issues brought up by government representatives with respect to the nature of that report, they might raise issues like they might say that that report is out of scope from the original intention of the bill S2. That's a possibility. I'm not sure if that will happen, but it all depends on if the federal government is going to undertake certain procedural tactics to sort of question the will of the committee and the decision of the committee. But if it's able to, successfully be leave is granted for the report to move to third reading within the Senate, therein lies an opportunity for debate within the chamber as well on the nature of the bill. People can debate against the bill. You can even introduce amendments in the bill at third reading in the Senate. But if it survives that as well, then it moves over into the House of Commons and they go through their process. It's introduced. There, would be second reading, then likely referred to their committee, INAM committee, and then it would go through third reading and, things like that. Or, so that's the typical process. The final stage for a successful bill is when it gets royal assent, it's called, by the Governor General. And that's when it officially becomes a law. And
Okay.
it is from that point that the year will start to apply.
Oh, okay, okay. And roughly how many people you think will become registered over time when these changes are ultimately approved?
You mean with the removal of the second generation
Yes.
crop? That's a very good question as well, Alicia. We one of the witnesses we heard from a couple of witnesses with Stats Canada that have done some extensive research on numbers and where they look at demographic trends of the rate within not communities but generally between the children that are born from status and non-status sort of parents. And there's been various ranges that they introduced depending upon fertility rates and things like that. So it can go from anywhere from, I think, 205,000 down the lower end to as high as 320,000.
Mm-hmm.
Now, that number has been projected out into to roughly 2066. So that's the number one looks at that far out into 2066. Historically, when they had projections, like on, for example, Bill S3 dealing with the Deschanel decision, a lot of these projections don't really hit those high marks. For some reason, there is a lower number of applications, and there's even a lower number from those applications of individuals who actually get registered. But at the end of the day, even if it was the case that those numbers were met, what we're essentially talking about, if we looked at 640 First Nations from within Canada, that might equate to roughly 12 people within that particular community of year. Like if that's, of course, if
Mm-hmm.
every community was of the same size, they had the same fertility rates. Of course, that's not the case. So
Mm-hmm.
obviously the numbers would be higher for the bigger communities and the smaller communities.
So do you possibly predict like a financial strain on First Nation communities if the new abundance of registered members come up?
Well, hopefully, with increased numbers of status Indians through these provisions, that there would be increased funding for communities from the federal government to accommodate these numbers. Um, there's a legal relationship between the federal government and status Indians. And part of that relates to the provision of programming and services, things like health, education, child welfare, things like that. So you would hope that there would be an increase in funding because that funding sometimes is determined on the basis, on a per capita basis, that is the number of status Indians within a particular community. And if that were to rise, then the logic is that the funding provided to those communities should rise. But, we also heard evidence from First Nations like Chief Whitford out of the Ochees Nation that has said, despite their status numbers, their community gets underfunded by the federal government using old numbers, right? Like they're not,
Mm-hmm.
the federal government is not adjusting their numbers to
Mm-hmm.
meet current status numbers within their community. So they're operating at a historic numbers that are much lower. So So it's always a discretionary call, for government to really do what's right and provide funding for status persons. Yeah.
Senator Prosper, you said today during the hearing that this is a question of survival for Indigenous communities who could face extinction. Can you elaborate on that and explain what you mean? What is at stake here?
Sure. That's a great question, David. You might recall that I referenced trends, demographic trends, and there has been some individuals, people like Stuart Clapworthy, an actual demographer that has done extensive research for various First Nations about looking at the historical trends of intermarriage between status and non-status parents, and the numbers indicate that for, if not all communities, that rate will provide or lend insight to a certain date where eventually there will be no longer any status Indians located within any particular First Nation, just by the rate of parenting between status and non-status parents. We had a press release last week with members of the Grand Council who supported my amendments, but also with Chief Alan Folches, a Wolastoqey chief there in St. Mary's. And, he predicted within the next 10 to 20 years, given the existing trends and the number of 6'2" status people within his community, that it could be as early as 10 to 20 years where you will not have any status persons left within a particular community. So, these are serious issues. This is, the survival of our communities and nations. And it's always been within the discretion of, the nation to determine who their members are, who their citizens are. They know who is part of their community. They have their own customs, values, and traditions to make that determination. And certainly it's recognized by international law through the United Nations Declaration of the Rights of Indigenous People. It's recognized through domestic law, through the United Nations Declaration of the Rights of Indigenous Peoples Act itself. And it's recognized within Canadian law through Section 35, which recognizes and affirms Aboriginal and treaty rights, but also the protections afforded through the Canadian Charter of Rights and Freedoms. These are discriminatory laws, and you cannot deny citizenship or status to individuals on the basis of discrimination. It's something that has to end. It's been incredible advocates through the Indigenous Working Group on Sex Discrimination and others, many others that have been advocates and calling for this change for decades. We're talking over, 4 decades that this issue has existed. And so now is the time to act.
Senator, today I think there was some concern expressed that this amended bill won't make it through the House of Commons as amended. But then on the other hand, those supporting your amendments countered that the time has come to end this, as you say, discrimination. Could you comment further on that or elaborate on that point briefly, please?
Yes, I heard that. I mean, I think one of the committee members, Senator McNair, who voted in favor of Bill S2 on amendment, unamended, that is, put forward the notion that, it could kill the bill kind of thing. I think, that with a court decision, there's an obligation of government to remedy those injustices that the court has found. So I think the bill is in good standing that, if anything, they just might take out, which would be very unfortunate for, if when it goes over to the House of Commons for them to take this amendment out. It's certainly within their powers to do so, but part of the parliamentary process, part of the role of the Senate as well as a chamber of sober second thought, is to truly represent the interests of minority groups and provide a regional perspective as well to the deliberations within government. And the evidence is compelling. I mean, I would ask anyone listening in to take in those proceedings, listen to those witnesses, and come up with your determination. I don't want to be pessimistic and say government is only concerned about, wanting to spend as least amount of money as possible. It's always been a plan, we know, for the federal government to get rid of Indian people, for them to slowly assimilate and become into the, a part of the larger Canadian politic or society. But you know, but it's important to recognize that we're talking about belonging. We're talking about people's lives. We're talking about identity. We're talking about culture. We're talking about traditions. And these elements are important. They were important historically, and they're just as important today. And it's incumbent upon every government official to recognize that we have constitutionally protected rights as Indigenous people, and there is an obligation upon government to respect those rights, even though if that may mean funding a few more Indian people.
So we've been speaking to Senator Paul Prosper. Thank you for speaking to NB Media Co-op.
Thank you. This was
Thank
really
you.
good.